All right. Well, today we are talking about the Executor Handbook. So just as a laugh, I put that photo up saying, please delete my browsing history. But of course, there's a lot more that goes into it than that. And so I wanted to start with some of the questions I sent in the preparatory email for this class, because everybody has some different concerns when they look at this whole issue of passing on information to whoever handles an estate or your affairs. And so I want you to look at this through whatever's more important to you. Perhaps you're the loved one worrying about things that'll happen to you if you pass. Or perhaps you're worried about your spouse or another close loved one who at some point will approach end of life, and you're worried about how you, the executor, might deal with these issues. So regardless of whatever your perspective is, I'm going to go through a few questions. And if one of these questions or more than one really resonates with you, please make a little note of it, because I'm going to break out with a question time, and I'd like to know which of these most concern you. So the first question is, if a loved one dies, or if, again, in each case, if it's you who is passing and your estate is moving on to your beneficiaries, are you worried about the executor's ability to pay bills, to be able to handle the affairs, just to keep the household running? Okay. Another question is, are you currently worried about the fact that even though that death may not be imminent, or perhaps it is, are you worried about your ability to do the role of a durable power of attorney, whether it's for healthcare matters or financial matters? Is that a concern for you right now? Third question is, do you know where all the documents are? By you, again, meaning either you the executor, or you the loved one worried about your executor, where all your documents are. Are you worried that those documents, you know where they are, but they're either out of date or out of state, or may not be pertinent where you are today? Another worry for some people is that there's this plan, but you're worried about your ability to execute it. You might need to hire professionals, that it's overly complicated or distributed between multiple parties, perhaps like a co-executor role, or children are in disagreement, or somebody who is going to do things is backing out, those types of worries. Another one is, are you worried about the completeness of the information? Do you actually know about all the accounts? Do you know about all the life insurance policies? Are you in a situation where it might be difficult for you to find out? That's a common worry. The next one, the worry you might have is, do you understand what the tax implications are? Are you well versed on things like step-up basis and non-probatable assets? Or is this generally confusing to you? And if you had to figure out where to pull a lump of cash, you really would be hard-pressed to explain what the tax implications would be. Okay. So that might not be a top-of-mind worry, but if you can't really address those answers clearly, then it should at least be of some concern to you. Are you worried about contested assets, squabbles between beneficiaries, that things might not go, even if your best laid plans or your spouse's best laid plans may not come to fruition? Is that a concern? Okay. Are you worried about things that have been set up in trusts, whether they're revocable trusts, like a living trust or a guarantor trust, or if they're more complicated, irrevocable trusts for a variety of reasons? Are you worried about how that's going to play out if the owner of those assets passes on, and if you have to become trustee, or conversely, if you have set up those trusts and somebody else has to administer it after your passing? Okay, I know we've covered the solo ager problem, but that may be your main worry, is about having no one to administer the estate. Are you worried about debt issues or claimants against the estate? Is the plan almost overwhelming? Do you have things that your spouse has set up for a variety of reasons that you feel you don't understand, or that will be very difficult or expensive to administer? You might have to get a personal advisor and pay a fee for percent under assets. And then lastly, do you have business or real estate interests that may be problematic for the executor? So before we break out and just get a feeling for what of those concerns might affect this group, I want to say that I'm not going to go into any details about trusts except revocable trusts, beyond mentioning that all the complexities of these types of trusts should be in an executor handbook. You need to give guidance on where to find the information. And then secondly, my caveat is that I'm going to limit tax matter discussions to the things shown on this chart, and we'll go into them in the rest of the charts. So because that becomes classes upon classes itself if we go into that. So I'm going to break out right here. And just see out of those questions if anybody wants to speak up about any topics that may concern them most. Otherwise, I'll assume it's kind of spread all over the place. No particular one? Go ahead, Nancy.
Well, certainly I do have the concerns of a solo ager. My husband and I are the last of our lines.
Okay.
So we need to have someone to come in and clean up after us.
Yep. And Karen?
I would have a question, I guess, about the professionals. If people have, say, a tax professional and or a financial advisor professional and or an attorney professional, and then the people that are managing the estate later are in different states, are there concerns about that as to whether those same professionals can practice in a different state in order to assist that person?
Okay. Okay. I'll go into that somewhat in this document, and then in some cases there are some issues where you will need somebody licensed to practice in the law where the estate is being settled. That'll be on a case-by-case basis. You can generally get 90%. You can get good counsel in other states, with the exception being, I would say, if the person is in another state, we are a community property state. There's some issues associated with this being a community property state. It really would be good to get advisory counsel on financial and tax matters from someone in this state. So we will go a little bit more into that, and then Karen, we can revisit that again at the end if I haven't touched on it. Lynn?
I'm also interested in the topic of solo aging.
Okay. All right. You know, that is the hardest one of the bunches we talked on last week. I will say that I have seen among people doing solo aging, I have seen people use Vanguard's personal advisory service, mainly because they're worried about not just the issue of death, where things may be more straightforward. You know where you want things to go. You're worried about administering your affairs and making sure there's cash in the bank when you're in a period of precipitous decline.
Right.
Some people have used Vanguard service because it has a lower expense ratio. Some people have used elder care firms, though I have not found ones that have the official elder care law subspecialty on them. What I've noticed is missing is it seems like there's very few firms willing to undertake the basic bookkeeping for paying the bills. And that seems to fall on the backs of friends. And I think it's because of a liability issue. Imagine if you're a bookkeeper and you decide to take on the fiduciary responsibility of spending somebody's cash down for basic affairs. They're out there, and I know people have them, and a lot of it is done under informal arrangements. But all my advice for you to tell you to find a fiduciary and somebody with those letters after their names to do it, it's a very, very difficult task. Very difficult. For just the basic bill paying one. You can find somebody to manage the investments, to handle your insurance policies, annuity issues, legal disputes, but the basic bill paying is tough. So I think that's why a lot of solo agers, if they can afford it, move into more of an institutional environment, a continuous care facility, or something else where everything is provided and the number of bills is minimized. Of course, that's expensive. All right, I'm going to go back on. We'll have our next break is we're going to split things into a time frame, what people need to do in the near term, short term, long term, because those are natural break points. And I don't want to go into so much minutia, and I won't. I'll touch on each thing at a top level, and then we can break out and see if something needs more detail. So I'm going to go back to the presentation. And we touched on this last time, that prior to the death of a loved one, A durable power of attorney will allow that loved one to have somebody to act in their behalf, even if they are incapacitated. And as you'll see on future charts, you may find there's a lot of last minute things to sweep up as somebody becomes chronically ill, terminally ill, or close to death. And so having a durable power of attorney, someone who will sweep up these things that may not have been intended to, will help the disposition of your estate immensely. So I have given links here for the Wisconsin State Law Library. Be aware that, of course, you should get these documents drawn up at a lawyer, or if your state is simpler, there are some good, do-it-yourself recommendations, software out there. But for any complexity, any open questions, get good legal counsel. And if your estate is simple, then let's say most of your assets are maintained at one brokerage or bank, those banks will have durable powers of attorney limited to financial transactions at that bank. And if you pre-fill them out and assign powers to that person using the bank's form, at least that realm of your worries, that realm of anything associated with that bank or brokerage will be taken care of. So my husband and I have done that at Fidelity and E-Trade, for example, just so it's absolutely indisputable that my husband and then our daughter as contingent can step in and play a role at those institutions. So they do have their own forms. And if there's a physical office, you can almost invariably go in there and get them completed. Okay, so this concept of an executor handbook is a book meant to assist your trusted contact during the period of incapacitation before your death, if there is such a period of time, if you have a prolonged period of time, and then of course after your death. So a lot of people think of these types of things as something for, after I croak, this is the information they'll need. A lot of this information really should be compiled and put in place before, while you're healthy, as I've counted on the table about that. But that should actually be in the handbook, so that there's a checklist for somebody if you enter a period of decline. Now, there are a lot of templates online, and I've looked at a lot of them. But one of the things I've found is really common among these templates and books is things are separated by topic. And that's important. That means if you're really unfamiliar with the subject matter, you can decide to look up things about, Social Security versus creating inherited IRAs. And that's important. But the problem is, as an executor, the most common thing you hear about is, what the heck do I need to do first? And then what do I need to do second? And a third. So there's a temporal aspect to this. And people need to understand not only what the stuff is they need to do, but what order they need to do it in. And in fact, if they're pressed for time, what can they push off versus what absolutely must be done up front? So those of you who have worked in projects or project management, I just put up a chart like this because this is what it feels like to be an executor if there is any complexity to the estate at all. It feels like there's this list of all the stuff you have to do. Some of it overlaps, some of it's in the future. But that's okay for you to think about this now, and instead of being worried about it, think about it as a set of tasks, a set of milestones with a good process and a set of risks. So every one of these bars, these tasks you have to do, you need to know what the consequence is if you don't do it now. And with good information, this will take a lot of the alarm out of the process. So I can't overstate that the concept of presenting this information in a timeline as opposed to a book with a bunch of data will do so much to reduce the stress on anyone acting as your executor, or if you're going to be the executor for someone else, such as your spouse. Okay, one of the things I have found helpful is that as you do pull this information together, if something is a particular document or a thing, it may seem like such a simple thing, but put it in bold font face or something to distinguish that this is a thing. This is a thing you need to go find. This is a piece of information. This is a will. This is a revocable trust. This is a durable power of attorney. This is a set of end-of-year statements located in a file cabinet. Whatever it is, let people know what to call it use consistent nouns. A lot of people just throw things out very nebulous and they don't detail exactly what it is the person should be looking for. The next thing is about handling passwords, sensitive data, lock combinations. Make sure that you keep them in a separate file. You got two choices. Put them in a separate digital file or physical location, and I'll go into digital versus physical later. Or you can have a primary document that has literally everything in it. That's the gold standard, probably hanging in a very secure file cabinet or fire safe. You can have that so the executor knows exactly where that is, but I recommend you have a redacted version of that. Do not hand out everything in one big document to even your trusted contact far before your imminent decline. The answer is that's an extremely dangerous document with all that information. It's the keys to the kingdom. It's the keys to identity theft. And it is literally everything about you, even including your draft obituary, your parents' names, their maiden names, all the things that would go on a death certificate. There really would be no document more compromising to you than this estate handbook. If, for example, you were to give it to a child and they were to leave it out on the table and the document disappeared. Okay, so I'm going to tell you the reason it's good to have a redacted document is because and I'm calling them trusted contacts now because I haven't gotten into the word executor yet. The reason it's good to have a redacted document is it lets you give the document to somebody and you can talk about it without all the passwords being there, the account numbers, where you keep your fine collectibles. Maybe you have gold bullion in the closet. I don't know, but whatever's sensitive to you, you need to talk with your trusted contact without shoving everything over to them. And a redacted document will give you a way of doing that. So that's your two approaches. One is to separate everything out to begin with and have a document that defines the process with the sensitive data somewhere else, or have one big document and where they redacted in, and then have a redacted version of it. Whatever works best for you is great. The reason you need this redacted document is a lot of people will be very hesitant to undertake this task if they do not know what is involved. And so to be fair to them, if you give them something without the sensitive information in it to them, you can talk about it. You can talk about it and show how things are done in chunks and that they have no worries that they won't be able to find things. They will be set up and they will be empowered. And that's the message that you need to talk about with this trusted contact before you can assign an executor, even if that's between your own children. So now we can talk about picking that executor. And the first thing you have to remember is that regardless of how you feel about that person is going to be in a position of power. Okay. Now, if you only have one child, or if you're only giving to one child or one cause or one nonprofit, and there's no issues of jealousy or family arguments, or one child received a lot of money when mom and dad was alive and the other didn't, or one child is doing really well and one child is not. If you don't have a lot of those issues, this may not be a tough decision for you. But you have to figure out who amidst your pool of candidates is going to be fair and equitable, as well as open, as well as reporting, satisfying the fiduciary responsibilities of being an executor. You might have somebody who is very well organized, but tends to play everything close to the chest. That's going to be a problem. Even if they're capable of doing it, if they're not transparent, it can divide families apart. So pick an individual who can remain civil and transparent under a mountain of tasks. So now let's figure out how we can make that mountain of tasks a bit less formidable. So since this is an executor handbook, I suggest a portion of the book be pre-death. Things that really need to be done as a checklist before the person has passed, because that may be your last time to rectify some deficiencies. So here's one, and this has helped me personally. Log into Medicare, your Medicare supplement plan gaps. If you're having a protracted period of declining health, have your executor to be get familiar with you about printing out EOBs or any open big medical bills you might have, or let them understand that you're going through a course of treatment so they won't be surprised by medical bills that may come after you pass. Or they can identify perhaps charges that shouldn't be there. There's all sorts of things that need to be reviewed if there has been a lengthy decline with lots of bills. Of course, make sure your executor understands your burial arrangements, body donation plans. Tell your executor where these important documents are, where to find them, okay? This is another thing. It causes real problems after the fact, which is if the executor, we live in a digital world now. Even if you'd liked to do everything on paper, you may find that certain things at time of death still come in. Acknowledgments that changes have been made still come into the email of the person who has passed. Okay. It may only be a transitory period. It may only be a week, but it's still really important to be able to, if the loved one permits, to be able to see their email, because so much confirmation changes of account status. For example, if you make a request for an account to be closed and the distribution's made to beneficiaries, you want to make sure you see that information. And it may not be, because these are human beings involved with systems, they may not have rolled over to your email address yet, and the confirmation that the account is closed will go onto the loved one's, the deceased person's email. You need to be able to see this if you can work that out with them. So that's why I say update your will. Most wills now are recommended to include a digital policy. In other words, not just physical assets, your home, your car, but your digital policies, access to your email, access to your social media accounts. You want to go into those social media accounts and you want to strip out all the information about dates and places of birth, because so many people read the obituaries and attempt identity theft against people who have died. So you want to be able to have access to those digital assets, and that should be in the will. Okay. Before the person dies, they should talk with the executor about any survivor benefits they anticipate will be passed on to someone else. Not everything has survivor benefits, of course, but some types of annuities and pensions do. Lastly, your executor should know where all the identification documents are and items needed for access. So that's not just passwords and email logins. That's things like phone pins. Practically all of us now have to have two-factor authentication on our phones. That may be the one thing that during this period, if you're listed as a trusted contact on a loved one's account, that may be the one thing that helps authenticate you in this period of transition. Physical keys, locks, combination codes, fire safes, computers, digital storage devices. The executor needs to know where all that stuff is. I think it was a lot easier in some ways when everything was on paper, because now everybody has a different way of doing things, and you have to have a candid discussion with your executor about what things are digital, what things are in physical formats. Maybe you only still use checks. They need to know where the check register is. Maybe you're a person who's super worried about security on your brokerage account, so you have a UB key or some other authentication token that lets you get into your brokerage accounts. Your executor needs to know how you manage to do all this. Where are the tax records? Where are the end-of-year statements? Probably all digital. Maybe you don't even have them on your computer. You use a Google Cloud service. Again, executor needs to know all this. Okay. Depending on the person who has passed, they may be living a very simple life, or they may be living a very complicated life. If they use a physical day timer, if they use a to-do binder, my mother kept this big pad on her desk with like a calendar, and she wrote everything in the little squares. You know, that was really helpful for me after she passed. It let me know who she talked to, what bills she might have had outstanding, you know, all these types of things. Seems small, but I tell you, when you're an executor afterwards, and if you don't know about this stuff, you're scrambling. You don't know where this information is, and you've got nobody to ask. So talk about it and put it in the Executor Handbook. If you write it down, they don't need to ask anybody. They'll know. Talked about stripping the social media account of identity theft type of information. I'm not saying close it. I'm just saying put a security lock on all that personal data. This is a side point. I won't go into it, but if you own assets at Treasury Direct, there's some joint titling and transaction right things you need to assign to your beneficiaries. And then suggest your executor might need to arrange for some time off. Okay, that sounds silly to say it, but I mean, it can take a bit of time. And if they have to think about that at the last minute, they may be in a bit of a bind. So now you or your loved one has passed away. And what would you want to put in your executor handbook about that? You'd want to explain that after death, a person needs to be moved out of any institutional setting that is being paid for in part or full by Medicare, an end-of-life policy, a long-term care plan, because once a person is deceased, nothing gets paid for. Okay, a lot of people get surprised by that and think they have some time. You don't. Okay. You conduct the burial, cremation ceremonies. You bring family together. You notice it's understood that you're going to handle those things. You put in the executor handbook those things you think reflect the wishes of you, the loved one, and what your desires are. Make sure that's conveyed. Okay, the next thing you need to do before all hell breaks loose and you get overwhelmed is secure the keys, the phones, the tablets, the computers, and any identification documents. Doesn't matter how you do it, just pull them all together, because the minute you start sorting and sifting through the house, you don't want that to get lost. Okay, the word exec here is just my shorthand for the executor. The executor should ask the nursing home, hospice, or morgue if they've notified Social Security. They almost invariably do, but if you're in a smaller town or smaller facility, they may not have. You make a request for death certificates from your local vital records department. You notify any private health insurers that might have been providing health coverage for the loved one. And the executor should submit obituaries or public notices as required by the state. So write your obituary and put it in your handbook. Okay, they can change it. You're not going to be there, but give them the information that's important to you. That if you had to have a newspaper clipping written about you, what would you want to be in it? Make sure it's in the handbook. Ensure that any collectibles or valuable assets are properly secured. Because they're, particularly if there's multiple children, people will be coming in and out of the house. If you intend to have an estate sale, you want to make sure in a clear mind you separate out the really valuable things. Of course, take care of any pets that now need another person to care for them. And particularly in the case of, for example, people using a lot of narcotics, people who've been in cancer treatments, remove any dangerous drugs from the premise. In some households, there will be a heck of a lot of things ranging from fentanyl patches to all sorts of opioids. Make sure they get out of the house. And put it in your handbook. Put it in your handbook if that's a task that needs to be done and checked off. Okay, this is the point where if they don't have the handbook, they're really going to need it. They're going to need to find a copy of that handbook that doesn't have the redactions. So we're now at the point where we go to the tasks that are immediately after death, and then we'll take a short break. So the handbook needs to explain how the bills get paid. Now, once you've passed, there are probably still going to be bills that need to be paid, because presumably if you're in a home or an apartment or assisted living, your stuff's still in there, even if you're not. Electricity still needs to be on. Credit card statements still need to be paid. Probably the next month's rent will need to be paid if you have to do so until the house or living arrangement has been vacated. So this is the case with a lot of spouses. If one loved one pays the bills online, then the other spouse really needs to figure out what the heck they were doing if they've not been privy to the process. So the executor is either going to need to gain access to the computer, and be listed as a contact or even a co-owner on some of these accounts if they're going to do it online, or the executor can call and pay these bills by phone, or literally wait until they get a bill and pay by check. That's a lot more dangerous than it used to be, because so many companies now are no longer sending paper bills. And this is why more important than ever in an executor handbook, it's going to be really important that the handbook explain what types of things tend to get paid automatically or get paid online and there is no physical bill. Okay, please do not shut down the deceased's telephone. Okay, that's going to be your clue that something is amiss. So if you start seeing credit card alerts and if you start seeing attempts against a financial account, that may be the only indication to you that somebody is attempting to access those assets. And identity theft and these types of things, when obituary is published, this happens. Okay, this happens. The other thing is that it may also be used as a way to authenticate you if you are already on file with a brokerage account as either a trusted contact or a on a durable power of attorney. Durable power of attorneys expire when someone dies, but it is still an authentication technique that they may use. It doesn't mean you'd be authorized to transact, but it means that they could identify it was you on the telephone. So in any case, keep that person's telephone around. Do not shut the account down. Same thing with whatever they were using. If they had a computer with a little portable USB drive where all their data was kept on, make sure you make a backup copy of that, save the original, and work off the backup copy. Okay. If you live elsewhere, if you're the executor and live elsewhere, the handbook should address how to forward the mail. It might be very simple as going to the post office or using their online account for forwarding to shift it to a new address, or it may not be so easy. You'll have to figure out how to get that mail. You might have to pay a neighbor to go open the box and send it to you every so often if you've got a good relationship with that neighbor. If the loved one has died in an accident, the executor must get all the information to that accident up front. That would include timely police reports and figuring out how to work with the insurance company if the loved one happened to have accident insurance. And a lot of people do. Okay, so what I'm going to do is I'm going to stop there for just a minute. So we've covered pre-planning steps and things to be done right near the time of death. Do we have any questions on this so far? No? Okay, Susan? Susan first and then Nancy. You'll need to unmute yourself, Susan.
I missed where you said what do we contact to get the death certificates?
In most localities, it's called the Department of Vital Records.
Okay.
It's found under the Health and Human Services branches in your local. And I'm sorry, I should have Dane counties right at the tip of my head, and it's in my executor handbook. But
Yeah.
that's what you need to look up is vital records.
Okay, good. Thank you.
The funeral home will often ask you how many you want, and they'll take care of ordering them for you.
Yeah.
So
Super.
just ask for way more than you think you need.
Absolutely. Funeral homes may put a price markup on it, though. Just some of them use that as an exploitive way. If you want to wait till it's at the Department of Vital Records, you can get them for much cheaper. That's the only reason I mentioned that. But yes, absolutely, the funeral home will do it for you for a price. Nancy?
I'm wondering if you're already paying bills automatically through your bank and arrangement with the utility, for example. Does that arrangement cease upon death?
Nope.
That can continue.
Nope. It has to be handled by the executor, which is why it's the very next section we're going to go into.
Okay, but it can continue during that gap when those bills still come in, need to be paid. That sounds like
they have no knowledge. They have no knowledge that the death has transpired. So
sounds like a convenience for that period, but then you have to take action to stop it, of course.
exactly, and that's where things get dropped. And then the executor has to go back and find out 3-4 months later, there's been all these things taken out of the account, and then they have to try to recover it. So that's why executor handbooks, I have found that the templates for the basic information, just compiling data, are grossly insufficient to handle today's digital world. Okay, Barbara?
I was wondering, We have all of this arranged. We did all this summer. So we were pretty sure that we were prepared, but from what you're saying, I think this could be a rather difficult situation because one of our sons is in Minneapolis and our other son is in New York. And they're going to be co-executors that we have the duties split in two, whichever one we think is the best for handling that job is assigned that task. But one's going to be here and the other's going to be on the other side of the country. Are there a lot of these things that we should ask a good friend to do, like the mail situation? And should we give somebody else permission to act on our behalf?
What
do you do?
Here's one solution that works with people remotely. With regards to the children being remotely, that's going to be more common than not. And that's why a lot of times the executor in advance, if you have a bank account that contains no more than enough money, let's say to pay 2 to 3 months worth of expenses, you can create a joint holder on just that bank account. Let the executor be able to pay bills from that account legally, have access to log in so that they can do bill pay from that account and pay bills anywhere. That's a very common one. The reason I say don't have more than 2 to 3 months worth of money in it is when you put your child on that account, they now have legal claim against all those funds, including if they get sued or if a debt collector comes after them. That's their money now as much as it is your money. So if you feel comfortable having a child to manage your bill paying, that's certainly a very, very easy way to do it. With regards to the mail, I don't know that a lot of people will do it, but my husband and I used to travel all the time, and then we had to move a lot. He was pilot. And so we used a mail forwarding service. There's quite a number of them in both Texas and Florida. I still have it to this day. All my accounts, their mail statements and everything get mailed to Florida. They are fiduciary. They have a legal obligation to hire people who will not open your mail. They will scan it for you. This means this is a position of trust. So all my mail that comes in there gets scanned. I never have to get any of it physically. I get copies of it digitally. And if you set something like a professional mail forwarding service with scanning services, then your children will be able to open and read your mail from all over the world. In addition, if there's a physical check that comes to that address, you can have the mail forwarding service. You can tag that mail as something you need to physically get, and you can give them an address to mail it to. So I have found that very, very helpful when people are scattered all over the place. One common mail forwarding service will do this for you.
Why not do a change of address? Have one of them do a change of address so that will automatically forward all the mail to that one kid.
Well, yeah, that's what I set up in the briefing, but she was talking about multiple children. So I was just, for total transparency, you can give multiple children access to a mail forwarding service with scanning. Because the United States Post Office only scans the outer envelope. It doesn't scan the documents. So that's the difference. That's the only difference. Yes, the best thing would just be to forward the mail. Okay, then you get all the physical documents. But if you have multiple people who need to open documents and read them remotely, let's say a brother and a sister doing so on behalf of parents, and they don't need the physical mail, or they move a lot, or they live on a boat. The reason these services are so popular is it satisfies the needs of the RV community and the boat and yachting community. Okay, so that's why these services exist. But yeah, forwarding is, as Karen has said, is the conventional solution. Nancy?
Yeah, we have tried to get the U.S. Postal Service to forward our mail for periods of 5 weeks. And they say, don't ask us to do that. So I had not known about these other. Sorry?
It's not performed reliably for you? Is that what's happened?
They just say, no, we don't do that.
that's why I use a 4-fee service. It costs me something like $19 a month. But because I live in an apartment building now, I have a tiny little mailbox that's that big. Now I get no mail. So all my mail still goes to Florida. It's all scanned in for me. And then if I need something important in that mail sent to me, they send it to me. It's just a suggestion. It's really made my life a lot easier. And you can authorize other people to log in and see all the scans. So if you have a complicated estate, give this some serious thought. I mean, a lot of people use it for exactly this purpose. Okay, Karen?
And hopefully everybody knows that we can all see the front of our mail that we get every day if we sign up for that service from the post office now. So we could give that password to our family too, and they could see what's coming to our mailbox, but only the outside envelope.
Only the outside. That is correct. That is correct. And so when you're trying to handle estate matters, though, and read the bill, you need the inside. And that's what a professional 4-fee mail forwarding service used by business professionals all over the world. This is very common. That's what they do. Just make sure you choose a really reputable one. And there's 3 to 4 of them in the United States, used by hundreds of thousands of people living on both boats and RVs that use these services. They've been around for decades. This is not new. There's nothing new about this at all. I'm going to go back to the briefing then. Okay, so we've handled the first week or two. We are now with things we need to do within the first month. So make sure that you distribute the important cherished memories in accordance with the will or the desires expressed in a revocable trust, or even through verbal conversations if you have nothing else. This would include things like albums, painting, decorative arts, items of most sentimental value, and as well as most tangible value. Okay, the handbook should reiterate, it should try not to create situations where you put something in a handbook that disagrees with your will. So it's important that you be consistent. But at this point in time, the executor should have no surprises about who's going to pay the near-term bills. So if they don't have a shared bank account, and if the assets haven't been distributed yet, which they probably haven't, it's only week 1 or 2, well, then they're going to have to self-fund paying these bills until the money is dispersed. So it's a question of whether or not you want your executor to be in that situation and how you would handle it. So make sure the handbook is clear on how they should both, and your will, compensate themselves or fund your payments that need to be made around the time of your death or before your death. You may indeed have quite a lot of outstanding debts. I don't know. The executor can be jointly listed on some assets so that payments can easily be made. But again, my big caveat is generally I wouldn't recommend more than a few months of normal spending expenditures, just enough to close down your estate. Of course, the executor is going to be a beneficiary. Well, no, not of course. You may very well have an executor that is not a beneficiary of assets, but they may be. If it's a child, then that executor may be a beneficiary on assets, so that once they get the distribution, they'll be compensated for anything they had to put up front for the estate. So what determines all this? What determines it is how the assets are titled. If your executor is not titled on the asset, they have to use their own money to pay. Okay, so the durable power of attorney again ends at the time of your death. So unless you have a trustee roll over those funds, you won't be able to access them, to spend them once the loved one has died. Okay, so again, now the executor is going to review the check registers and any financial applications that you may be using. So some of you may be like me and using Quicken, or what used to be managing your money, and some of these other applications, whatever superseded Mint. You might be using any one of these tools to keep track of all your bills. Make sure your executor can see this information, even if it's physical stuff, day planners. Here's what needs to be in your handbook, and it will help so much. What needs to be paid one time? In other words, if you know a big bill is coming up and it's got to be paid, let the executor know, because the executor will have no knowledge of it otherwise, because it won't be in your past spending record. Okay. If there are current payments that need to be stopped, put a list of those vendors in your handbook. Okay? If there's a list of deposits that need to be stopped, pension payments, some royalty relationship you have with someone, put it in the handbook. Tell them what needs to be stopped because you died. Okay? And then also what recurrent bills have to come up even with the death of the deceased. So I know I'm beating on this, and I apologize if I'm too redundant, but this is just such a great help to your executor to know this information. The next thing is, again, because your will now has been updated to reflect digital assets, right? Since it has, your executor can access your email accounts. Let them know how to do so. If you don't want them to see certain stuff in that email account, then get it out before you die. Just strip it. It's kind of like clearing your browser history. If there's things you don't want around, clean up the house before you get to that point, all right? If you use unique domains like I do, if you're not using a Gmail account or something that's out there in the public, if you're using a special domain for your email, you need to tell the executor who owns that domain. So for some of you have written me and seen Cheryl at hebel.net or me at hebel.com. I own that domain. I own hebel.net. I own me.com because I handle more sensitive information and I like to have the domain fully under my control. I don't want it on a Google server. I don't want it on a Yahoo server or an AOL server. I don't want it anywhere. I want to own it. So if your loved one handled mail in that fashion, you need to know who the domain registrar is because that domain could turn off if the bill doesn't get paid. Okay, so if I didn't pay, in my case, GoDaddy, which is a big domain registrar, if I didn't pay them, my mail would turn off. Okay, so just that's something that doesn't affect a lot of people, but it's really important if it does. Okay. So the reason it's helpful to review the loved one's email frequently is because that's where a lot of account closeout information will go until it rolls over to you. There is a transition period. None of this happens instantly, and sometimes it doesn't even happen properly. They'll still keep sending stuff to that old email address, okay? And you'll have to call customer service and make multiple requests to get things done in a timely fashion. Okay. It's also a good reason to review the email because if you don't have a clean check register, or if you're having trouble rebuilding the financial history, you may find if they were making mistakes, if they were getting scammed, if they were overpaying bills, paying bills twice, things like that. You'll also find out, the executor can find out if the loved one had entered into any new contracts or financial obligations within the months of their death. Now, this is really important, particularly if the loved one was in a period of cognitive decline and maybe have been being taken advantage of or just made poor decisions. And now we get to the biggie, which is Wisconsin requires a will to be filed within 30 days. And this is different to me than in other states. Other states, if there was no probatable assets, you really didn't need to do anything. Nobody was going to come after you for not filing a will. Okay. But everything that I can see on this, and again, if there's any questions on this or if this bothers you, always seek legal counsel, is that it is required for every deceased person. The writings seem to be pretty unambiguous in that regard. And it's filed with the Register of Probate. And it must be done even if there are no assets needing probate. And we'll go into what that means in a minute. No lawyer is required to file the will there. And nor is a lawyer required if you're in a no probate situation or an informal probate situation. You certainly may choose to use one, but it is not required if you're in either of those situations. So this is the website for the probate office. So one of the things your executor has to do, and to me, I was used to having 60 to 90 days in other states. 30 days is really, really onerous because the executor has to figure out which of your assets need to go through probate, versus which ones don't. So we need to go into what that means. And if your executor does not speak financial talk, that could be almost an overwhelming task. In fact, they might err on the side of caution that everything needs to go through probate, when in fact it doesn't need to go through probate at all, and they will subject themselves to procedures that are unnecessary and cumbersome. Okay, so ideally, any item, let's talk about, you have a taxable account with some stocks in it. Okay, that account, if there's no beneficiary declaration, if there's no transfer on death or paid on death declaration, if that account is not held within a revocable trust or joint account, then we're going to call it, and if it's not held by another entity, I mean, there are more things, but generally speaking, if it's solely owned with no beneficiary, no transfer on death, not held in a revocable trust, then it's subject to probate. So your goal in life should be to die without anything going through probate.
It's not the one account though, it's the total of all accounts. Right?
Well, I'm speaking about one account within all of them. You can have some assets that need to be probated and some that don't. You can have some that have had beneficiary declarations, and you could have left off, could have forgotten to put a beneficiary declaration on one account. That account would need to be probated.
Right. And I'm just saying that your 50,000 is
In
cover
aggregate,
all
yes.
accounts,
All of them.
all
Yes,
accounts
yes.
in summary that do not have that declaration.
Yeah, that's it here in total, but more than, below 50,000, but more than zero in total. In total, correct. All right, now if no probate is required, okay. In this particular case, without going into details of forms, look into this. There's Wisconsin has form PR 1831, which allows for simplified transfer via affidavit. I don't want to go further down this rabbit hole because I am not a qualified person to go into the subtleties of these forms with you. But I wanted to point you to these assets so that your goal should be not to have anything probated. It just makes a lot of work. There may be, because of family situations or whatnot, you feel it has to be probated. There are exceptions to every rule, but in general, you want to have nothing be probated. Because if nothing needs to be probated, then all you need to do is file the will and you're done. Okay. So how can you avoid probate? So we've already made very clear, you can have lots and lots and lots of assets of all types. Real estate, brokerage accounts, IRAs. You can have all of this stuff and have zero to probate. Okay. So assets can be held in living trusts. So if you do have an account that's titled in a revocable trust or a living trust, then the trust itself will dictate what happens at your death. It does not need to be probated. If you own something jointly with another person, jointly in this case without respect, with rights to survivorship, that should have been clear on here, that won't need to be probated. If you've declared a beneficiary or transfer on death or paid on death, it won't need to be probated. Okay. If you give it away, it won't need to be probated. Okay. If it's assigned as a gift within a QCD or other type of special flavored retirement account or a donor advised fund, it won't need to be probated. Okay. If you have a life estate deed, it's called a life estate deed, or a ladybird deed in Florida. It's called a transfer on death deed in Wisconsin. If you have these types of deeds, it doesn't need to be probated. Okay. So there's a lot of ways to avoid probate and make very clear what your wishes want to be without going to probate. So if you make it so that your entire estate doesn't need to be probated, you have done your executor, you've given them the greatest gift. Okay, so now we're ready to go on to the next section. I'm going to break right here. See if we have any questions now about these things to do within the first month, about bills, probates, that type of thing. Any questions? How do most of you feel? Oh, yeah, go ahead, Susan. Yeah.
So I'm just thinking about the gift thing. You said if they've been assigned. So if one of my children is going to have an antique cabinet from the family, can I write that goes to this child?
No, you have to actually give it away while you're alive.
Okay, got it, got it.
Because otherwise it's just a declaration in the will, and it has to be administered by the executor, who is your fiduciary, and then validated as a result of the execution of your will through probate.
Okay. Can you give it to your child, but they allow you to use it in your home?
If you're dealing with life estate deeds, that's exactly what a life estate deed does with the house. But if you're talking about a collectible, you'd have to make a contractual and probably largely unenforceable agreement.
Yeah, good. Okay, thank you. Just wondering.
Okay, Suzanne. Oh, you're muted. Unmute yourself.
Hi. Yeah, quick question. And I think we talked about this a little bit last week. I don't think that there was an answer. Maybe there wasn't. I missed it. But if you are, okay, so I have a transfer on death deed to my daughter, and then properties to go to her children
On a house.
on a house, right?
Okay.
Now, something that did come up last week was when you're in the, and okay, so I pay my house insurance annually, right?
Mhm.
State Farm gets a check from me, it's paid for 12 months. Say I die 6 months into that 12-month period, the house goes to her automatically. Does the insurance continue? I mean, is there something, somehow this has stayed with me since last week, and it's causing me to lose sleep. So
I think where we left it last week was every insurance policy I've ever dealt with between states or between owners when I've passed real estate interests exists for a period of time, relevant, very short period of time, relevant for you to conduct the transaction. And ideally, what you should do is you notify, of course, you don't know when you're going to die. Okay, it's a little bit different on date of death. But if someone is permanently ill or you know a date is pending, you should reach out to the insurance company so that they understand when to effect that change for you, that you will be contacting them within a week after the death, because they understand they do that all the time. Okay. So
for instance, I mean, what if I was hit by a car? Let's just take worst case scenario there. And then my daughter inherits the house the day I'm hit by the car. My insurance, and she contacts my insurance person, but you know, she'll have to cry a little. She'll have to do it. This is what she said to me, Mom, just get this handled, because I don't, you know, I will be emotional. So she's got to be emotional for, you know, a day or two. Is my insurance?
we all know intuitively that there's a period of time required for notification. So what I would say is contact the insurance company and find out what that grace period is.
Okay.
Yeah, I really would recommend you to, because it's going to be just pure conjecture here. But you know, accidents happen all the time. So yeah, it's
Yeah.
I understand it's a worry. So give them a call. You should be able to put that worry to bed in short order.
I don't want to set my insurance agent off thinking something's going to
Well,
happen.
then make up something ludicrous, really. I mean, really, you use the old hit by a bus scenario. Just say it's been weighing on your mind, okay? Yeah.
Right.
You can't file, they can't say you filed a claim, you're not dead, okay? So, all right, Karen?
Yes, that was concerning to me too, since last week. So I stopped in at my agent's office, did not call the insurance company. I contacted my agent, and she said that the insurance would be covered until it was due again. So if you pay once a year, it'll be covered the rest of the year. And she said, make sure that you have someone designated to check in on the house if it's unoccupied. And she said, just communicate with us directly, the agent.
My address is 6306 Lakeview. It's all one word.
All right, somebody needs to mute themselves.
MIDDLETON, Wisconsin, 53562.
Okay.
No,
I don't
I'm
know where
not.
that's coming from.
Okay, I think I got it. All right, very good. So let's see. Nancy, I muted you because I thought there was another voice coming. It's
When I registered for this, I said
That could be my husband in the next room.
It is.
Try to deal with that. I'm so sorry.
Okay, go ahead. What's your
I've tried to
question?
shoot him out. We had a somewhat different experience in Indiana. And I lost my connection there.
Oh, you're there. You're there.
Or did we all? Different experience in Indiana with my mother-in-law's house and the insurance. It all worked out, but I would strongly suggest contacting your agent or the company and knowing in advance what is required. And
Yeah,
just
it
put that into
differs
your
between
binder.
insurance companies. It definitely
Yeah.
differs.
Yeah, talk to them sooner rather than later.
Okay, any other,
to know.
moving on from the home insurance issue, any other questions? Suzanne, did you?
I just had a quickie. Karen, who's your insurance company? Just a quickie.
Erie.
You're right. Okay, thanks. They're supposed to be one of the best, incidentally.
Okay, any other questions about things in this first month, particularly that we talked about relative to probate or wills? Okay, we'll go on to the next topic then. Okay, now that we're done with the easy stuff, we get on to the harder tasks for your executor, which is if they have to convey, you may be the executor. So if you're the spouse, it's one and the same. You need to contact pension plans, turn them off, invoke benefits for the survivor if this pension plan has survivor benefits. Oh, hang on here, not squeeze this so much. The executor needs to not just take on faith what customer service tells them. When it comes to complicated things like pension plans, annuities, second to die life insurance policies, the executor needs to have the original documents in their hands if they can get them, so that they believe that whatever is being implemented is in accordance to what the loved one bought originally. So for example, with pension plans, there's pension plans that have no survivor benefits. There's pension plans that go 50-50. You get 50% of it, 75% of it. You know, you want to make sure it's being done the way it's supposed to be done. So the executor should have access to that information, and you should put it in your executor handbook where that information is. If you have, let's say you've been sick for a while, but you still kept your house, so somebody's checking in on it, you need to contact those property managers. If your loved one was in a union at the time of their death, oftentimes unions have a variety of benefits, either at time of death or for the survivor. You need to contact any third-party providers of benefits. For example, let's say your husband was on COBRA healthcare, not Medicare, was still working on COBRA, had COBRA secondary, and you also are on the plan. You have all these issues where you may have been sharing benefits or using third-party providers. You need to contact them and make sure that you, the beneficiary, or you, the survivor, has continuation of benefits where you were expecting them. Do not expect it to go smoothly. Do not expect it to happen automatically. You may be really lucky, but most of these things have some hiccups along the way, but the hiccups are much smaller if you do it proactively and call them as soon as you can. Okay, we're going to talk about separately the closing of the retirement and after-tax accounts and how those are rolled over. Here's the thing, if the loved one had life insurance policy, whether whole or term, there's going to be a procedure to file life insurance claims. Once you've gotten through the will and the probate, this is the time to do that. In fact, I know in my parents' generation, and still now for a lot of people over 60, there are active life insurance policies in force that the loved one bought these policies to benefit their surviving spouse. So don't hold off too long to do this, and certainly call them before you get a next premium or payment due to make sure that the life insurance policy knows when the person died so that you can initiate your claim. We've talked about accident claims and legal claims. This, of course, could be a huge task if there was a serious legal dispute and you'd need to get good legal counsel to pursue that. Okay, if there were any solely owned assets, those things we talked about that had to go through probate, which hopefully you don't have any of, but if you do, your executor is going to have to open an estate if it's over $50,000, possibly if it's under $50,000, if there are any disputes involved with its transfer. So probate will be opened. Probate process will assign a personal representative. That personal representative will have to take an inventory of your whole estate to declare all of it, but then identify which of those issues are solely owned, pay the debts and taxes, and then distribute the estate. So again, this puts a whole layer of burden on your executor, a whole complete layer of burden. I can't tell you what a headache it is. Now, everybody here will know somebody for whom it went simply, but it doesn't necessarily go simply. And it depends on how backed up the courts are as well. It could be a very simple estate, but just take a long time to process. So it's different in every location. Opening an estate requires getting a tax ID, an EIN number, which you can do online. It's called an SS4 form. Again, should be in your handbook, because if your executor doesn't know to do it and isn't one for digging through the internet for hours or getting a book and reading it, then tell them in the handbook. It may be the only thing they read is this handbook. So you have to tell them that it needs a different tax ID. It's not your social security number. The estate is not your social security number. So dying without a will and navigating problems in probate is beyond the scope of this class. That's all I can say about that. Debts. Okay, I have less experience with this, but debts are indeed the responsibility of the estate. You don't get to just not pay the credit card bill. Okay, you can't you could walk away from it, but then again, still the estate process would be involved, as long as there are any assets in the estate to pay debts. So these debts need to be paid before the assets are dispersed. Now, if there's not enough cash to pay, then assets are going to need to be sold. And that might be a problem, particularly if these are illiquid assets or difficult to move. If there's more debt than value held in the entire estate, then yes, the debts will likely just go away. The debt collectors will decide they're not worth being pursued. You can't get blood out of a turnip. But if you have co-signed anything, then that's a different situation entirely. So with co-signed loans, all parties are liable. So just, this is why people are often discouraged. Don't enter these types of transactions later on in life, or but if you do so, enter into these transactions with the full knowledge that whoever supersedes you is going to end up having to pay that debt in full. Okay. While the general statement is that if there's no cash in the estate left, the debts go away, it may differ in community versus non-community states, or with filial responsibility laws in which the children have to pay for medical debts of their parents. It varies by state. It's beyond my pay grade. So you'll have to look into this matter if you do have some debt obligations that you're concerned about. Beyond that, the executor does actually have a fiduciary responsibility in the eyes of the state, meaning that they can be held for the debt if they actually knowingly fail to follow proper procedure. They are responsible for making sure the estate pays out if there's the cash to do it. So don't be an executor and assume that because you just choose not to pay it, it won't fall. There won't be a consequence to you. Okay, so part of it is just my background in computers and computer security, but you never know. Your loved one might be using a USB drive attached to their computer that's 10 years old and on its last legs. Don't let that be the only thing. You don't assume it's going to work tomorrow. So again, like I said at the beginning, make a copy of this stuff. If there are really important things you look at all the time, print them out, put them in a binder, make backups of things. If you have a secure cloud service, put a copy there. Just don't assume that digital media will work the next day, okay? Okay, for some estates, these might be big topics. I'm only going to touch on them on this one chart. There are trusts that are created at time of death. A lot of people may still have these in their will. So if you and your husband made a will 20 to 30 years ago because you thought a big company merger or some patents or a business somebody owned was going to make it big, and if you lived in a state that had estate taxes, you may have put things in your will like testamentary trusts. So if you looked at it today and you didn't know that your spouse did that, you might go, I don't know what that is. It sure doesn't look like it applies to me, but it might. In other words, if some of these things are lingering in documents that are decades old and they no longer apply to you, get your will rewritten. So for example, we lived in Maryland, my husband and I, in our 20s and 30s, and ever hopeful, you hope you're really going to make it big. And Maryland had a very low wealth threshold for estate taxes, very low, one of the lowest in the country. So our lawyer at the time had us create a will that had testamentary trusts, meaning that in order to not pay the high estate taxes, I think they were 16% to the state of Maryland, money would flow into two types of trust, a family trust and a credit shelter, or what used to be called a bypass trust. That became an irrevocable trust, which could be used for all my needs while I was alive and then passed to my children. It was a way to take a huge slug of cash out of my estate so it would not be subject to estate taxes. And so all across the country, people did this if they lived in a state with low estate tax thresholds. That all changed over time. The thresholds went up higher in nearly all states. And then in 2017, a tax reform act passed, which means that people don't pay estate taxes unless they have more assets over like $14 million per person. So that would be $28 million in a household. So if you're looking at your will and you say, oh, that's not going to apply to me because we've got nowhere near that much money, it might if it's been poorly written. You just don't want to get shoved into these trusts because you forgot to rewrite your documents. And I won't beat this anymore, but they are found in a lot of wills. And so you need to look and see if there's any irrevocable trust language in your will. If there is, decide if you really want it. Again, if you inherit a business or rental property, the handbook needs to tell you how to deal with it. If the loved one was a trustee on irrevocable trusts, you can't just walk away from that. You need to find out who the successor trustee will be. And the executor needs to inform the successor trustee that the loved one has died and that they need to take over the responsibility of that irrevocable trust. That might be a special needs trust for a disabled child, for example. And then, if in the year of death, the loved one gave away gifts exceeding around, I believe the current limit is $17,000, you still are obligated, the executor, to file a gift tax form if they have exceeded the annual exclusion. It's not hard to do, but if you're not familiar with it, it's a little bit weird because you don't declare the amount of the gift. You keep a running tally of this really big number, which is the lifetime gifts you can give, and you subtract out all the gifts you've ever made. So it's really kind of wonky when you first look at it. Again, as an executor, this is something that can take up hours worth of time that a professional tax counsel could do in 15 minutes. Still has to be done though. So if your loved one did gift a lot in the last year of your death, that form has to be filed. It needs to be in your executor handbook and prompt your executor. Okay, so if you share an account with a child, let's say, to handle your affairs as you decline or after you die to pay the bills, just make sure that you understand any assets in those accounts while you're alive and still need that money are subject to claims against your child. So that's why I suggest don't keep a mountain of money in it. It doesn't mean your child's done anything bad. There are numerous frivolous lawsuits in this country. Okay, your child can encounter claims which have no bearing in fact, but which could be a claim against assets and take a while to settle in court. So parents sometimes put children on their accounts early on to build a child's credit history, or later on when they become concerned about managing their affairs. Okay, if you do that, your handbook really needs to go into detail about how you pay your bills. Don't assume they can figure it out. You may have a linked brokerage account or something that they're going to have to do forensic work to figure out how you do it. So make it easy for them. Again, tell them about recurrent deposits. Tell them the procedure to move money between accounts, and then give them some advice. For example, if you happen to have a brokerage account that has bonds that mature every year, or you use I-bonds at Treasury Direct, or you rotate Treasury bills at Fidelity, so that you have money that settles in the brokerage account, and that's where you normally pull money, tell your executor that. Because they may go off and sell highly appreciated stock before it's been dispersed and be subject to taxation, whereas if they had inherited it, it would have no taxation at all. Do not assume your executor understands these critical pitfalls. And if you don't understand them, figure it out now while you're healthy. Okay, so your handbook, give them some advice about what they should use for cash, immediate cash. Now, that's going to be the first question is, what the heck do I liquidate if I have to pay a big bill? So pictures are worth 1,000 words. So in my executor handbook, I keep anywhere from 2 to 6 months worth of cash in a linked Merrill Lynch account tied to Bank of America. Merrill Lynch does not automatically sell things in my brokerage account before when Bank of America gets really low or whenever a bill has to be paid. It has to be done manually. I don't like that, but the interest rate is so good in their Treasury Trust money market account that I hold my nose and I do it this way. So this is in my Executor Handbook that says, go to Merrill Edge. It's linked to Bank of America. It tells them how to log in. This is where you need to do. Click that button. Okay. Right now, there's only $2,600 in that Treasury Trust account. Click that button. It comes up with information about how to sell that money market. Click sell, put the dollar value here, and then go to this transfer screen. I've obviously cut out a lot of the text. Go to the transfer screen and move the money to Bank of America here. This way, your children who may have never seen a Merrill Edge brokerage account will know how to do it. And they'll know what you want them to sell. And ideally, if you're very sick, I mean, this is what I plan to do, is if I know I'm not in my right mind or feeling ill or, you know, in the middle of a difficult period, I'm going to probably put 6 months to 12 months of spending cash in that amount if I feel that somebody else has to care for me for a prolonged period of time. I want to make sure they have cushion to pay my bills so that I can be sick for a long time till I can get back and take control of things or expire. So this gives them the details on how to do it. Okay. Do we have anybody raise your hand if we can talk now? If does anybody have any questions about bill payment? No. All right. Well, then I'm going to go on to the tasks of the next 3 months. You're like, oh my God, we're still in the first month. Now, like, that's why the plan is as big as it is. And that's why I believe a lot of these quick help books that you buy on Amazon that just arrange things by topic, they don't really give the executor that much help except to give the account information, which you would have done on your own anyways, probably. Okay. All right, here we go. Okay, so most people are pretty good about knowing if there is a life insurance policy, they're going to file that claim. So I have no doubt your executor will do that. The main thing is that you may forget to tell your executor to notify everybody else that if the deceased loved one was a beneficiary on their policies, they need to change their policies. So you not only have to go file the life insurance claim, but while you're in the mindset of life insurance, maybe you had a life insurance policy. Let's say your husband died. His claim is paid out. Maybe you don't think about it and you have a life insurance policy that's only payable to your husband. Well, he's deceased. Maybe the life insurance company did not allow you to declare a contingent beneficiary. If you don't update your life insurance beneficiary to someone else, what will happen is if you die, that asset will be probated because it will go to the estate of your dead husband. This is something people forget all the time. So that's why I have it in here. Your executor handbook has to say, don't just file the life insurance claims. Look at all the other life insurance policies are out there and see if the deceased is named as a beneficiary in any of them. And if he or she is, update those life insurance policies. Okay, Social Security, I think most people understand the survivor benefits. I'm not going to repeat that discussion. We discussed it in our last class. I will say that for survivor benefits, my understanding is, and as we know in this administration, it could change at any time, but my understanding is you can't do this online for survivor benefits. You have to call or go in person. So just keep on top of this, that this may take a little bit of time. Do not become alarmed if it doesn't happen immediately. It will be retroactive to the date of death. In other words, if the whole system is gummed up and things are falling months behind, that's a very little consolation, except it will still cover the retroactive period up to the date of death. The clock ticking does not mean you're losing those survivor payments. Okay, be really annoying, but the other thing I would recommend you do, and it should be in the executor handbook, is to remind the executor that you, the survivor, if you're the survivor and the executor, They're phasing out that username and password combination. You're going to need to move over to login.gov or id.me. So rather than waiting until a time of grief, get it set up now. Don't try to jam everything to the last minute and wait till you are bereaved to try to do these things. It's hard enough dealing with Social Security right now. Doing it in a time of grief is when you have technical problems, not something you want to have to deal with. The other thing you should do right now, if your spouse dies and you are handling the settling of his or her affairs, go on to your Social Security portal, scroll down to the bottom, and if your spouse was declared as the only advance representative payee for you, you need to change it. That person is deceased. So an advance representative payee is the very fancy phrase for trusted contact on the Social Security portal. So if you log into Social Security and go all the way down at the very bottom of the main home screen, there'll be a place called Advance Representative Payee. That is a person authorized to act on your behalf if you are incapacitated. You can declare them in advance. That's why the word advance is there. That way, when that person calls on the phone, they can authenticate that person, and you have already indicated that they have authority to act on your behalf. That's a huge help for them, by the way. Otherwise, they don't know them from Adam. They won't speak to them. They'll have to go through all the normal in-person processes that happen when you become capacitated. They have to go out to the office. They have to fill out forms, oftentimes get a lawyer to help them with this. If you do this simple thing in your Social Security portal, you will save that person a mountain of labor. Okay, now we're to finally we're to dispersing assets. Okay, so one of the things your executor will need to know is to not make a very common mistake, which is emptying an account, transferring an account, exchanging an account, or transfer in kind. Okay, to every extent possible, I would suggest, because let me say why. To every extent possible, I would suggest they move assets in kind. Why? Because those assets have probably appreciated, and if you move them in kind to whatever vehicle they're going to put them in, they get the step-up basis. They get the much higher value for those assets. So let's say, I'm sorry, they're doing road work on my road. It just started. If you hear that grinding sound, it's outside. Let's say you bought something for $50,000 and it's now worth $100,000. And it's a stock or a bond. It doesn't matter what it is. If they move it to their, they may want to keep that stock or that mutual fund. If they move it to their account in their name now, because they're the beneficiary, it is now has a basis of $100,000. So that's really important, because if time goes by and it's now $125,000 worth, if they sell it, then they only have to pay capital gains on $25,000, the difference between the $100,000 they inherited and $25,000. So they may want to hang on to that. Just make sure that they understand what they're doing if they cash something out, because if it doesn't get dispersed and the estate sells it while it's still owned by the deceased, that's a capital gains on the full amount by the estate. So don't do that. It's a huge tax implication. Oftentimes brokerages, people have horror stories where they say, I told them to transfer everything, but they didn't say transfer in kind. Some brokerages have been known to liquidate the stocks and bonds and only transfer cash. Same thing with the word exchange. If you don't see the word in kind, then you should assume it's going to be liquidated and converted to cash. Now that may well be what you want. Maybe the loved one had a set of highly appreciated assets, and you really need the cash. Maybe there's debts to settle. You have no choice but to sell them. Okay, just make a conscious decision about what the tax implications are for your transfers. So here are things that are stepped up in basis. First of all, we're only talking taxable assets. So if it's in an IRA, the IRA will get rolled over, which we'll talk about. But the step-up basis occurs only in taxable accounts. Okay? Real estate investments, businesses, and the equipment in the business. That's a powerful thing. If you've run a business and you've grown a business and then you die, it's extremely satisfying to know that when that business or that piece of real estate, whether it's personal or investment, when it passes to your child, they get the full step-up basis on that. That's one of the greatest means of American wealth transfer in this country. The step-up basis is how people get truly wealthy. It is the underpinnings of dynamic wealth. And it is also definitely a tax favor to the real estate industry. Okay? So whether we think it creates an inequitable society is another question entirely. Because this is how wealth accumulates to the already wealthy, is by being able to pass on things with this step-up basis via inheritance. So as a social policy, it may have some severe consequences for inequities. But as a wealth preservation policy, you can't beat it. Okay, so make sure your executor understands this. I'm sorry this has become a tax class, but people find out they paid tens, thousands, hundreds of thousands in taxes when they didn't need to because they didn't understand this. Or the executor never checks after the assets are passed on that the basis was updated. So this is what your executor needs to do. Okay, so any surviving spouse in the U.S. is entitled to the step-on basis of inherited taxable assets previously owned by the deceased. So we are in an unusual situation, however, of we live in a community property state. So if you thought it was already good to get a step-up basis, it's even better to get a step-up basis on not only what you own, but what your husband owned, so that even when one of you dies, you both get a step-up basis on marital property. Wow. I mean, that is, I mean, a lot of people call that literally a tax loophole. But nonetheless, if you have money and assets and taxable assets, this is to your benefit. It is legal to do this. Make sure you do. Get tax counsel or financial counsel and talk with your advisor to make sure that it is handled properly. Now, I haven't been in Wisconsin that long, so this is pretty exciting to me. But I was like, how do I prove this, let's say, to E-Trade? So the question is, maybe I'm entitled to it, but does it happen automatically? And I think the answer is it should, but it probably doesn't. So what you have to do at E-Trade, for example, is you have to take your joint with rights on survivorship accounts, and you have to retitle them as one that has a community property account. In other words, you have to tell them and sign a piece of paper that says, yea, verily, I'm in a community property state. I fully understand how this works. Okay, now, is that a technicality or is that a legal requirement? I don't know. I'm too new to this, so I don't want to give you bad advice. That's why I'm really caveating this. But after looking at this in some detail, that is my next step, is to see what I need to do to my accounts to make sure I get the benefit of that double step-up basis. You should look into it too, and maybe after we figure it out, we can figure out how it worked for us. Okay. So I've given you some links here so you can see I'm not making this up. Lots of pictures, lots of working examples. All of this is here. Make sure you seek tax counsel if you need it, because if you are in an ultra high, if you're one of those people with that over $14 million problem, then it's going to be more important for you to keep your assets separately to control your estate taxes. But since I am not that lucky, this is probably going to be the best deal I'm going to get. Okay. Step-up basis. That probably has more of a financial impact on anybody who has even some money. So if you have more than a few $100,000, this is something you really need to understand. Now we go on to retirement account distributions. Make sure that your handbook says that if the loved one did not take the RMD before their death, in the year of that death, then the executor has to do so on their behalf. Okay, just because a person died that year doesn't mean they get to avoid their RMD. They still have to pay it. Okay. And if they don't, the executor must do it for them, or there are significant 25% penalties on this. So that is something you need to do. You do have a period of time to say, I'm so sorry, I didn't know I had to do that, but it's only up to the next December 31st of the following year. The law has changed, so it doesn't have to be one person paying it. All of your beneficiaries can decide together to chip into that final RMD if you didn't pay it. But really, I think everything's easier when one person does it, because that way you're sure it's credited correctly. The most important thing the handbook should tell the executor is that when people inherit their IRAs, if they are not the spouse, they don't have the rest of their life to spend this money down. They did up until 2017, but then the law completely changed. So it used to be that you could do something called a stretch IRA. If you had an IRA and you died, and the IRA went to your, and you were the surviving spouse, or single or widowed, your IRA would go on to whoever you're declared, and they could use their actuarial life table to pull out their RMDs based on how long they are predicted to live. The IRS publishes these tables. They could have that money for the rest of their life and spend it down just as if they had funded that IRA. That is no longer the case. Now they have to spend it down in 10 years if they're a non-spousal beneficiary. Now, if you think you're doing a child, this is where it gets really interesting from a tax perspective. If you have a good bit of money, if you have $1 million in that IRA, you have to think about if it might be worth gifting some of that to them now, even if you use up some of your unified gift tax credit. Because if you give them $1 million in an IRA and they have to pull, and they decide to pull it out in relatively equal increments over 10 years, and that's going to grow, but so let's say they pull out $110,000 a year, because there's some growth in it. The rest of it keeps growing as you pull out. That might knock them into a significantly higher tax bracket. So you've given them a gift, but your gift, the gift being the inherited IRA, that gift came with a heavy price tag, didn't it? You shoved them into a 12% higher tax bracket, perhaps. So that means your gift, what you thought you were leaving as a legacy, just got a great big haircut. Okay. That may not have been what you intended. So if you have a good bit of money, think about that, because gifting sooner rather than later, whether to your child or someone else, may be a benefit if you're dealing with a larger estate. Okay, and that applies even if you transfer a Roth IRA, that the 10-year thing applies. So this is a chart. I know the print's really small. I'm not going to do it, but it basically says beneficiary flow chart. Post law changes 2019. So you've always got to check. Every time you do this, you got to check. Don't assume my chart is the latest. I think this one is. But it basically says if you are a charity or a state or an entity, you have a 5-year rule. Now, see, that's really interesting. You might think you're doing the right thing, passing it to a trust or an entity, not realizing that now that $1 million or that $500,000 or that $1,000, whatever your estate is, has to be taken out in 5 years, much bigger chunks. Okay. Now, if they are a non-spouse beneficiary, then we have this 10-year rule. They can take it out in equal chunks, or they can wait till 10 years and do it all at once. Okay. So again, they have tax planning considerations, and it's helpful to mention this in your handbook, saying, yeah, you can wait to year 10, but in year 10, if you take it out of a traditional inherited IRA, you're going to have one great big honking tax bill if there's a good bit of money. Might have been better to spread it out over 10 years. Flip side is, let's say you are in your 90s and your child is already in their 70s and likely to have healthcare needs. Might not matter to your child if they wait and just take it out in the year they need it if they're going into a nursing home or need a high level of medical care, because they'll have a huge tax deduction to offset all that income. So I don't know how many of you have children that like to talk about this, but and this goes way beyond the necessary job of an executor. But in my mind, that the world has gotten so complicated with how we handle our retirement assets that it really helps to have your executor pass this on to the person who inherits, because it has a huge amount of impact on the value they get out of this money that you worked so hard for, that you have left for them. If they don't understand it, it could make the difference between 20 to 30% of what you gifted, of what you left to them. Huge, huge impact. Okay, so Suzanne, you have a question.
It's just a quick question now. When you were talking about if you have stocks, you should transfer them in kind because you get the step up in basis. So, okay, what if you have stocks that can't be transferred in kind and you have to sell them and transfer the money? In my mind, you would still get that.
That I'm not so sure, because that is, capital gains are based upon how an asset is titled and when the event occurred. Your intent might have been to gift it, and you might go, boo hoo hoo, they've handcuffed me and won't let me. The IRS does not care. Okay, if that asset is owned by the estate at the time you incur that capital gain, it was not gifted to you.
So here's the question. You have stock, okay? you have a payable on death, transfer on death of that stock to your child. They get the stock, then they sell it or whatever they want to do.
If they sell it instantly, they'll have zero taxes.
That's what I'm wondering. So I wouldn't be the one selling it. I'm just thinking in terms of my daughter receiving things.
That's why I'm saying transfer it in kind and let them make the tax decision and grab that step-up basis.
Mhm,
Now,
mhm.
let's take the opposite. You've had a capital loss. You've had a loss that's greatly depreciated, but you have other things you have to pay tax on. The decedent's account had other things that have to pay taxes on that year. If you have a capital loss, by all means, sell that stock, take the loss, and use it to offset the gains you have to pay on something else and reduce your tax bill.
Mhm.
So that's just good planning, regardless of whether or not
Right.
you're filing for an estate. But yes, generally with appreciated assets, roll them over to your beneficiaries in kind and let them decide when to sell them. The only caveat you have to remember is if you're dealing with penny stocks or highly volatile stocks, I mean, during the period of time it takes to transfer, which is usually pretty quick. Brokerages are very good at this.
But what I'm thinking about is I'm a retired state worker, okay? And TIA Craft was it's a managing party of the state retirement, right? So they have stock in that account that is their own. It's not you know what I mean? It's proprietary. Is that the word I'm looking for?
This is a case, for example, you're going to have to actually talk with them about this, because what I don't want to do is to say you could sell it or exchange it into something that's different, because then it might be treated as a wash, what they call a wash sale. You're going to have to go and talk with them. This is outside my area of expertise. I'm really good about saying what I don't know the answers to. Check into that. And make sure you explore that. And Beth, Beth, you're still muted. There you
Okay,
go.
my question is, if you are a part of an LLC, which I am with my brother for farmland management. Okay, upon my death, what LLC records have to, or his, whichever.
Yeah, that I can help you with. So you have in an LLC, and Beth, actually, you know what? Let me finish these charts, because I can go into depth with you about LLCs, but probably that's not of most interest to other people here. Let me finish the charts. Can you hang to the end so we can finish these last few charts? Okay. All right. We will come back to LLC member interests. Okay. So let me come back. Oh, actually, I'm still showing the charts. RMD ages have changed. Tell your executor to go see when they have to take RMDs. Just because somebody born in 1960 or later can wait till they're 75 years old to take their RMDs doesn't necessarily mean that they want to, particularly if it's a large estate. There are tools out there, one of them being MaxiFee, the one I wanted to show you guys. There are tools out there that say it might be better to start bringing down that fat IRA sooner so that you don't shove yourself into a higher IRMA profile and pay more in Medicare rates. So just because an RMD means you can wait till that long, there may be legitimate tax reasons to start it a little sooner. Okay, health savings accounts, just go over this briefly. Your spouse can inherit it. It will stay a health savings account, but my recommendation is that if you are the second to die, spend it down, because when you pass it on to your beneficiary, it loses all those wonderful tax benefits. It becomes fully taxable when you pass it on. So there's something that you can do, which is make sure the Executor Handbook tells the executor that they should spend any money out of that account in the year of your death. Just deplete that thing, because again, it's going to take a full tax hit all at once. You're not going to be able to spread it out. And you do have permission as an executor to withdraw funds for any medical expenses in the year of the decedent's death. So, and that may allow you to deplete it completely. All right, here's just remember I told you the mistakes that happen with life insurance if you fail to update your beneficiary listings after someone's died. Same thing with beneficiaries on other IRAs. Have your executor reach out to everybody and say, hey, did you have my dear loved one as a beneficiary in your IRA, either primary or contingent? Make sure they update their beneficiary listings on their own IRAs. And when they get this inheritance and create an inherited IRA, it'll actually be titled that way. It'll no longer be called a traditional IRA. It'll be called an inherited IRA for so-and-so on behalf of so-and-so. And it's titled just like that formally. But when you set up a new IRA, if you didn't fill in the blanks for those beneficiaries, that's going to be a probatable asset, okay? So you need to make sure and set your beneficiaries on any new inherited IRA that you set up, and it needs to be in the handbook. Okay. Finally, after all this financial stuff, we're into the rest of the things. And most people think of this type of stuff when they talk about an executor. So I've probably bombarded you with more tax information than you wanted. But that's where the buck stops, really. It's those poor choices that get made because people don't understand the consequences. But yes, you do have to close out the utility bills. You may find out, my mother had a credit card. She had no idea that there were rewards points associated with it. She had so many rewards points. I got all sorts of kitchen equipment out of it. So, you know, before you close down a credit card, check in and see if it has things like that. You might be really surprised. We talked about cancel, or as Suzanne was talking about, transferring home insurance, canceling subscriptions, updating the Motor Vehicle Administration, sending updates to colleges about, you know, alumni associations, mailing thank you cards to people who have helped you. And again, if you had to go through probate, which I hope none of you ever have to do, then there will be a slew of other tasks that are not in this briefing. So now we're on to the very end, which is the estate tax return. And so some of you may be thinking, I never have to do this. I'm going to come nowhere near close. That 14 or 15 million, I have to look at what the numbers is. I honestly don't forget it. But it's around 14 to 15 million dollars that you need to file one of these returns. But tax laws change. Remember, I told you I set up a will back in my 20s and 30s because the estate tax was down at $1 million, and some states even lower. Just because there's this high threshold now doesn't mean in the future that tax laws could change and say, hey, we're running a really deep government deficit. We're going to make sure that estate taxes get taxed for anything over $500,000. That may seem radical, but it's only radical in light of the last 10 years. They could easily decide that as a fundraising mechanism. So since we can't predict the future, I recommend you protect yourself. So if you have any money at all, file out Form 706. Why? There's only one part of it that you want. What you're going to do is you're going to declare the size of your estate. So that will give you an exemption. So you're allowed to have $14 million exempted from your estate. And you have an estate of $1 million. You're going to get a $13 million exemption from filing this on behalf of your deceased spouse, and that's going to roll over to you, so that when you die, you will have $13 million that you got from your spouse, an exemption from estate tax, plus whatever. Let's say your estate was $10 million when you died. So now you get his 13 million plus your 4 million. That's 17 million in exemptions. And I know these numbers sound radically large. The fact of the matter is they could change at any time. Okay, they have been all over the map in the last 30 to 40 years, and it depends on public policy. If there is low-hanging fruit called an estate tax exemption, my advice to you is to claim it. It's one form. There's no taxes to pay. You just declare it. There's a box that you check called portability exemption. So now, as of 2022, this portability, if you forget to do this, you have up to 5 years to do it. But I suggest you should, because if the government ever wants to start reaching into people's pockets and lowering the estate tax limits radically, this will cover you. Okay. So the key is the loved one needs to keep no secrets to the grave. Explain how you do things. Explain your thinking process. Okay. If you had intended to withdraw from a stock bond portfolio at a fixed percentage, if that was your intent, tell them in the Executor Handbook and say why. Okay. If your intent was you had a bunch of treasury bills churning out there, inflation protected bonds, one matures every year and it goes into the bank, tell them so they know. Your kids may know nothing about bonds whatsoever if that's what you live off of. If all you live off of is pension and Social Security, let them know. Because that way they'll know if you have sudden cash events settling the estate, they're going to have to figure out some way to pay it. If you expect an insurance settlement or something else to fund their lifestyle, let them know. Okay. If there are second to die benefits on something, let them know. Survivor benefits. If there's any gotchas, if you know, let me give you an example of a gotcha. Let's say your loved one had some investment property and you know full well that nobody's going to be able to manage that thing. And nobody's going to be able to manage it, and nobody's going to want to do what they call a 1031 or a Starker exchange and roll it over into another property. In other words, that baby's going to be sold. Okay? That's a tax gotcha, because all that depreciation your loved one's been claiming all these years to make it such a, quote, profitable property are now going to be on the tax return, and you may have a big bill that's due. Okay? You need to put it in the document. You need, if you have these things going on in your life, tell the executor so that your beneficiaries don't get surprised. Okay. If you have things that have handcuffs on them, contractual handcuffs that are not easily liquidated, or that you've made oral agreements with somebody else about how that asset is part theirs, or you've made an informal agreement, for example, that this is particularly with real estate, that there's an easement, somebody has access to your property. There's numerous things that get done by oral agreements. Put it in the executor handbook, okay? If you have a plan for how you'd get cash fast, because it would be best for you and your beneficiaries, put it in the handbook, okay? Maybe your survivor might need a lump sum payment to go into a continuous care facility. If you tell them how you plan to pony up the cash, you will give them some clarity. And then lastly, if your spouse is not going to be able to manage this inheritance, have them seek a fiduciary. And if you've already done the homework, tell them who that is. Tell them who you would recommend, and then tell them who you would not recommend. So in this world, 41% of widowed women did not have a conversation with their loved one about how to manage these financial matters. And so try not to be one of those 41%. It takes and compounds, it compounds grief. Supplemental data sheets. This is what most people talk about in an executor handbook. None of the stuff I talk about, they talk about this. Okay. This is, I expect you to do this. You all are bright people. You wouldn't be in a Plato class. I know you're going to do this anyways. You're going to form a list of bank accounts, brokerage accounts, retirement accounts, Roth accounts, health spending accounts, healthcare accounts, life insurance, all other insurance policies, specialty insurance policies, pensions, collectibles, stocks, bonds, Bitcoin, non-fungible tokens. Hopefully you don't have any of those. You're going to put those digital assets in your will. Make sure that people aren't going to encounter any legal obstacles if they need to read your email. List of real estate with deed and ownership information. If you've got physical cash, if you've got a book that has one of those hidden interiors and it's War and Peace, it's on the fourth shore of the bookshelf, make sure they know it's there, okay? You'd be surprised how often people find cash only when they hoe out the place, okay? Don't let that happen to your loved ones. If you do use bonds as a way of funding the accounts, make sure they have a list of your bond ladders and all the CUSIP numbers. Recently closed accounts. Sometimes people will think an account is still open or not why it's closed. If there's something that you closed it recently, put it in the executor handbook so they don't spend time worrying about it. List of credit cards, list of mortgages, debts, list of legal disputes, list of claims against the estate, list of advisors and trusted professionals. And on behalf of a lady who told me that the University of Wisconsin Foundation for Alumni also has a kit to help you, I wanted to mention it here because it is a benefit you are entitled to. I am not a UW alumni, so I have not received this kit, but I think it's a nice thing to think of, and I encourage you to go to the website and look at it. I'm sure good care was putting into it, knowing UW. So now it's late. I know everybody's burned out. Beth and I are going to talk about LLCs. Any other questions? Karen.
Is the EIN only needed if there will be probate? You don't need it if nothing will go into probate?
That's correct. That's absolutely correct.
But you still will have to file the last tax for the deceased.
Yes, you know what? That was omitted in this. Thank you, Beth. In fact, before I send these files out, I'll indicate you'll have to file a final return. Yeah. Missed something. Okay, Suzanne?
Yeah, if any of you are state of Wisconsin retirees, don't forget that you have a life insurance policy, a term policy that you can convert to cash. So let your beneficiaries know about it. And it's like 50% of your highest pay, but it goes to cash. So that's funeral expenses. That's like, debt on you that you may owe, or you can take it to pay your health insurance premiums if you're getting your health insurance.
Who is
through.
eligible for this?
If you are a state of Wisconsin employee.
Okay, good point.
So I'm figuring some of you are, because otherwise you wouldn't be here and you wouldn't know about Plato. So if you are, just my neighbor didn't know this. He had called me about something and I said, don't forget, and we all do because it doesn't come up. But if you go to the ETF website, you type in term life insurance, it'll pull it up and it'll give you the information how to figure out what your piece is worth and what you can do with it and how you can convert it. But don't let that sit.
Money is money. Yeah, there's other things from veterans benefits as well as even Social Security. I think sends you like a $225 check at death. I didn't put in those details mainly because, as you can see, what my worries are. You can see my worries are the sheer confusion of the new world that we live in, done mostly online, and the serious tax consequences that result from the most of innocuous decisions. Most people will go through their life and not realize they just cost themselves, 10 grand.
Right.
And maybe that's a better way to live, honestly.
Oh, no. We just all have to live forever because this is so much information. You know what I mean?
Yeah, I have decided after taking this class, I am not going to die.
I'm with you.
It would be easier. I stumbled into this, obviously problems come home when you have to deal with them, but then I've seen this just multiplied again and again and again. Like I started in the first class, I explained everything and I saw, and I'm like, this is common. Everything I told you today is really common. I left out the uncommon stuff.
Okay, can I speak, Cheryl? I just want to say something to you. That continuing studies at UW-Madison used to have a course called the Sandwich Generation, and people from the community, I mean, I did it myself many, many years ago before I retired. A ton of people I know took it. It's continuing that class. It was like maybe $250, 2-day class, something like that, many years ago. But my suggestion to you is to propose this course to UW, to the Department of Continuing Studies, and see, this is information. I hate to say it, ladies, because we're getting this through Plato, right? And kind of inexpensively, but this is something you could get paid for, and it's needed. This is information that's truly needed.
Well, thank you, Suzanne. The thing that concerns me is I don't come in with the right letters after my name.
It doesn't matter.
Well, as long as it doesn't matter. I've actually been thinking, because this course really has the financial stuff and the non-financial stuff. But you can't really separate them. And the thing that bothers me is, like we see here, it's mostly us ladies here today. A lot of the men, they think they've got this all nailed down. They've taken care of this. They put these plans together. They've got these lists. They have not a clue about what they've omitted. And I don't mean this to be sexist or too gender slanted, but there's a confidence in the estate planning that they have no clue that all these problems surface, that all these I's were not dotted and these T's were not done. And we typically, often, women live longer, or it's the oldest daughter. We bear the burden of that. And I've seen it too many times. And it angered me. That's part of the impetus behind this, is that this is so damn difficult.
And this is a lot of information. That course was, I think, maybe 2 full days. It's been many years. I've been retired for
Well, I'm thinking about what to do with it. So rather than talk more on that here, what I'll do is I'll send out an email on this subject. And Beth, we can go to LLCs.
But Cheryl, don't assume that it's the way you said. Sometimes it's the woman who's the one who's trying to be very, very organized and get all this buttoned up, and the guys are not worried about it. It can
They're
go
not
either
worried.
way, either way.
Either way, yeah. So it can be, the money can be flowing either ways, but it's still the same sense that it will be okay. And it does become okay, but why make all this extra work? All right, Beth, LLC. So is this a multi-member LLC? You're muted. Some of you may find this of interest because if you can form an LLC for many, many reasons. Okay, it doesn't have to be for real estate.
Yes, it is for real estate. It has other assets in it though, just in order to support the real estate. And so it's primarily family members, with my brother and I having the controlling shares, very minor shares for other family members.
Okay, so here's typically what happens with an LLC. And I've been through LLCs for both real estate as well as for manufacturing interests. And an LLC, the member in each of you is a member and has a percentage membership interest in the company, right? And that's probably formalized through an operating agreement. Is that correct?
Correct.
Okay. Just to let you know, most states, the only agreements they keep on file is the charter documents, because operating agreements change all the time. So do not expect, the people in the LLC should not expect to be able to go to the state website and pull the operating agreement. They can find a list of who the officers are, but the state does not keep track of what percent membership interest you have. And that's important because people think it's listed somewhere and there's a way to validate it. There isn't. Okay. It's inside the LLC. You file an annual report every year.
Yeah.
So you file, the state knows who the officers are, but they have zero interest in handling battles between who owes what the valuation is, who it should pass to, what your buy-sell agreement is, all of that. So the first thing is, does your LLC, probably, very few do, but some do. Tech companies almost always do, even if they're small. It has buy-sell agreements. Do you have anything in your operating agreement that has special handcuffs on how things could pass from one to another?
I don't know. We address it within our individual wills.
Okay, that's most typical. All right. So what you've just done is that you've created a probatable asset, didn't you?
I was wondering. That's what I was wondering.
You can have your trust, your revocable trust, and this is what I would recommend. Your revocable trust can be the member in the LLC, and inside your revocable trust can say that I want my member interests in this property to pass to so-and-so.
Yes.
Now, the other thing is, and the reason I say that's important is because if it has to be probated, the probate court is going to want you to put a value on your percent ownership. In other words, there has to be a dollar value attached to it. You can't just say I own at 10%. Now, there are standard ways of doing this. For example, if you were a small manufacturing plant or a small retailer, you can use something like anywhere between 5 and 15 times EBITDA, the earnings after income taxes and operating sales. So there's standard metrics. Here's the problem that happens if you don't own it in a revocable trust interest, which is if somebody gets persnickety over this and wants to know what the value of the percent that you own is, you can spend $15,000 to $20,000 from a licensed appraiser to do this nonsense over a business where your interest might be worth $5,000. Okay, so just make sure you've got an operating agreement where nobody is in dispute about what percent you own. You can own it as a revocable trust interest. Make sure it's in your revocable trust what you want to happen to your member interest. Then you won't have to go through any of this. It is a private transaction.
Okay.
If you want to put handcuffs on who your interest can pass to, some family, particularly if it's multifamily, they want to have a buy-sell agreement, meaning that everybody agrees you can't pass your interest to a hostile party.
I'll look at that. Okay.
Yeah, that, again, you don't have to have a lawyer to do this. This is a privately held business. You don't have any public shareholders. You can do all of this privately. A lot of people say, get a lawyer, get a lawyer, get a lawyer. If it's just you and immediate family members, you can probably draft this up in a way that gives the children enough latitude to not be hamstrung with a piece of real estate they don't want, and have a way to to deal with it as a family. There could be a clause in there where everybody agrees if disputes get to this point, we sell it. You know, that should be thought of in your operating agreement or your buy-sell agreement.
Time to review the operating agreement and the revocable trust to see what's where. Okay, that's.
Yeah, now you could, this is unprincipled and unethical. If your member interest was very small, some people would, in practice, I know, not declare it. They literally wouldn't declare the members info. But you know what? You don't want to do that because it's traceable through the K-1 forms you get from the LLC.
Yeah, yeah,
I assume you're getting annual K-1s, right?
yeah, yeah.
Yep. The minute you do that, you either have to pass it via revocable trust. There's probably some other mechanisms that real estate pros would know. I'm just, you know, I'm too small a player in this. But I have paid for on a property that held patents that were not, we couldn't afford to keep them going. We had all these international patents. We overextended ourselves. We could not succeed. It's a classic new entrepreneur area. You get in too deep. You've got a big player who wants your patents, but is willing to let you fail because they know if you can't support it, the patents will go in. Again, ugly story, but we spent $20,000 evaluation for an appraisal on our membership interest for a company that wasn't making any money. I mean, it was ridiculous because we thought we had to do it, and you don't have to do that. Just come up with a reasonable assessment of what you believe the member interest is. And if your member interest is tiny, if you own less than 20% of the company, you get a minority, what they call a minority discount. Okay. All right. But that's important because
Your list made me suddenly realize, oh my God, the LLC has to be part of what's addressed.
absolutely. And it will be traceable because of those K-1 forms. Yep.
So thank you. This
All
is
right.
an amazing course, really has been. Thank you.
Thanks. Thanks. I appreciate it.
A lot of things to think about.
I don't think people realize the hardship an executor goes through till they live it.
Yeah.
Or they just don't do it. And then if you don't do it, then it's a financial hit. So take care. Bye-bye, everyone.
Thank you.